Good morning, everyone. Today is Tuesday, October 15th, 2024. Welcome to the agenda meeting of the Minnesota Public Utilities Commission. My name is Katie Sieben. I chair the commission. I'll now take the role of the other commissioners who are present for today's hearing. Commissioner Means.
Here.
Commissioner Hom.
Here.
Commissioner Tuma.
Here.
And Commissioner Sullivan.
Here.
A quorum is present. We have only one agenda item on our plate today. Mr. Bonnet, when you're ready, please introduce our agenda item.
Good morning, Commissioners. The item in front of you today has many docket numbers, but the primary docket number is E-002/GR-12-961. It is in the matter of the application of Xcel Energy for authority to increase rates for electric service in the state of Minnesota, the Sherco 3 outage-related issues. The issues in front of the Commission today are: should the Commission accept and adopt the Administrative Law Judge's findings of fact, conclusions of law, and recommendation? The parties are up front today and are prepared to make opening comments, and staff is available to answer any questions you may have. Thank you.
Thank you very much. Commissioner Hom.
Thank you, Chair Sieben. I have to make a statement before we start this proceeding. Before we start the hearing on docket 12-961, I'd like to make a conflict of interest statement related to my participation in this discussion and possible decision. At the time of the incident of the Sherco 3, I was employed by Department of Commerce. My role at the time was a developing record related to utility load forecasting in planning, certificate of need, and rate case, and participating in regional transmission organization workgroup meetings. My work in that role did not bring me into any knowledge, conversation, or decisions about the matter in this docket. Therefore, I'm not conflicted out of this discussion or decision on this docket. If there is any party who has information that supports a different conclusion, please bring that information to the attention of the Commission attorney.
Thank you, Commissioner Hom. And Commissioner Sullivan.
Chair Sieben, and regarding this docket, as is evidenced by the history of docket numbers on this, it's been around for a long time, including the time that I was the Deputy Commissioner at the Department of Commerce. For the reasons that I don't want there to be an appearance of a conflict of interest, I've decided to recuse myself from the matter at the Department of Commerce. I was party to conversations. I do think that it's best for me to recuse and not take part in the decision today. And for that reason, I will be dropping off of the WebEx after this.
Thank you very much, Commissioner Sullivan. We appreciate that, and we'll proceed to opening comments now by the parties.
Madam Chair, since we're bearing our souls, I apologize. There was a decision option related to the redlining that some people saw. I didn't want anybody to panic. It deals only with the question of whether we should be redlining or how we should be redlining. It will be handed out when we get to that point. I didn't want anybody to feel like they were left out in panic about what John Tuma was doing with regards to his crazy decision options. So,
it's not surprising, Commissioner Tuma, that you have a decision alternative. I'll look for it when you're ready. So we'll begin with opening statements, and we'll start with Xcel this morning. Mr. Harris, welcome. Please state your appearance for the record, and you have 5 minutes.
Good morning, Chair Sieben and Commissioners. Matt Harris on behalf of Xcel Energy. I want to thank staff for the briefing papers in this docket. This case has a voluminous record, and it involves a lot of technical issues. But once you see what's undisputed, the questions get a lot simpler. It's undisputed that the company's restoration of Sherco 3, its recovery of insurance proceeds, the decision to bring litigation against GE, and the settlement of that litigation were prudent. The ALJ also found that the company's chemistry practices were prudent and consistent with good utility practice. No party takes exception, so that's also now undisputed. The only disputed items then are 1, whether the company was prudent in following GE's guidance to not conduct a blades-off inspection of the LP turbines, and 2, if not, what, if any, further relief should the company's customers be provided. For the first question, your standard of review is undisputed. The company bears the burden of proof by a preponderance of the evidence, which means that the evidence in support of a fact outweighs the evidence in opposition by even 0.5%. By that standard, the company must prove, without the benefit of hindsight, its inspection decisions were within the range that reasonable utilities could have taken. As the department's witness suggests, this is akin to a definition of good utility practice, which includes, quote, any of the practices engaged in or approved by a significant portion of the electric industry during the relevant time period. So, what are the facts regarding the company's inspection practices? It's undisputed that the accident at Sherco 3 in 2011 was caused by stress corrosion cracking in the finger-pinned dovetails of the L1 row of one of the low-pressure turbines, the very first such event in a drum boiler unit like Sherco 3. And it is further undisputed that such cracking can only be identified with a blades-off inspection. All applicable guidance from GE, including after the event, expressly states this, and the department's witness agreed during the evidentiary hearing. It's also undisputed that the only applicable guidance from GE at the time of the event, which was the only applicable industry guidance or practice at the time, said that utilities should not remove blades with finger dovetails absent abnormal events, meaning it would be imprudent to do so. Despite this, parties argue, and the ALJ concluded, that the company was imprudent in changing its time between major outages, that a major outage in 2011 would have prevented the event, and that there were anomalies that should have spurred the company to consider a blades-off inspection. None of these points is supported by the weight of evidence. First, the weight of testimony, bolstered by contemporaneous documents from GE, is that at the time of the incident, inspection intervals were increasing to 9 years or longer, which is consistent with the company's successful prior transitions of Unit 1 and Unit 2 to 9-year intervals. That shows the company's similar decision to extend the interval at Unit 3 was consistent with industry standards and within the range of reasonableness. Second, the weight of evidence shows that a major inspection in 2011 would not have revealed anything about stress corrosion cracking. The department's only argument is that a, quote, bucket lift check could have been performed during the outage. But the weight of evidence, including documents from prior inspections by GE, shows that not only would such a check have not been performed, it would not reveal anything. This is consistent with documents related to similar checks performed at the Navajo unit in the 1990s that failed to reveal rampant stress corrosion cracking at that unit. Third, the weight of evidence shows that the alleged abnormal events were swiftly and appropriately addressed. And more importantly, as the ALJ noted, there is absolutely no evidence in the record that these events impacted the steam chemistry of Unit 3 or the long-term reliability of the unit. That shows that the company's decision to not perform a time-consuming and potentially destructive blades-off inspection was well within the range of reasonableness. In sum, and contrary to the ALJ's conclusion, which is informed by misinterpretation of evidence and a narrative expressly contradicted by testimony, the company's actions and decisions leading up to the event were prudent. So, what, if any, further relief is due to customers? If you conclude that the company acted prudently, then no further relief is warranted. That's consistent with the principle that prudently incurred costs should be recoverable. If you disagree, then any further relief should be based on the only replacement power cost supported by the evidence in this record, and it also must account for the prior rate case disallowance and an appropriate allocation of the GE settlement funds provided to customers. And that would be consistent with the case law the Commission asked parties to opine on. In the replacement power cases, utilities were ordered to refund replacement power costs, but their plants remained in base rates and they were afforded the opportunity to seek and presumably retain litigation proceeds. Here, Unit 3 was removed from base rates and all litigation proceeds were provided to customers. Therefore, to reach an analogous result, those prior amounts must be credited as an offset to any refund now. With that, we're happy to answer any questions you have.
Thank you, Mr. Harris. Next will be XLI. Ms. Lee, welcome. Please state your appearance for the record.
Good morning, Chair Sieben and Commissioners. Amber Lee with the law firm of Stoll Reeves on behalf of Xcel Large Industrials this morning. In an effort to move this to resolution, I'm attempting to use only 2 of my 5 minutes. Though the record in this proceeding seems never-ending, the issue before the Commission is straightforward. Whether or not Xcel's Sherco 3 replacement energy costs were reasonable and prudent, and if not, the amount of overcharges and interest that should be returned to customers. The ALJ's report in this matter is thorough and well-reasoned, and XLI requests the Commission adopt it with one exception, the ALJ's discount for GE's contributory fault. The ALJ correctly found that Xcel failed to satisfy its burden of proof that it operated and maintained Sherco 3 in a reasonable and prudent manner consistent with good utility practice, and that Xcel's failure to conduct necessary inspections and maintenance contributed to its catastrophic failure. As a result, the replacement power cost Xcel recovered from ratepayers should be returned. There is disagreement around the amount to be refunded based on which methodology is used. XLI's approach to this question is simple. The amount recovered from ratepayers should be the amount returned plus interest, and we support the ALJ's conclusions in this regard. In terms of offsets to the refunds due, XLI supports the ALJ's determination that 24.4% of the GE settlement should be credited against the refunds due based on Xcel's litigation position. We also support the ALJ's determination that no additional offsets are due for the 2012 rate case disallowance or any of the supposed benefits customers received during Sherco's restoration. We deviate from the ALJ's position only in the determination that GE's contributory fault should be considered in determining the refunds due. GE was not a party to this proceeding and has no obligation to Xcel's ratepayers. Xcel is obligated to refund all of the amounts improperly recovered as a result of its imprudence. XLI supports the following decision options: 2, 4, 5, 9, 14, 16, 19, 20 or 21, and 25.
Thank you, Ms. Lee. Next, we'll hear from the Office of the Attorney General Residential Utilities Division.
Just some clarity
Mr.
from Ms.
Murray.
Lee. There's a
Commissioner
lot of pages,
Tuma.
and I wasn't keeping that too fast enough, so I apologize. You're not proposing your 26 through 28 be addressed today?
That's correct, Commissioner.
Mr. Murray, welcome. Please state your appearance for the record.
Thank you, Chair Sieben and Commissioners. Good morning. Travis Murray on behalf of the Office of the Attorney General, Residential Utilities Division. As other parties have said, I want to thank staff for the excellent work on the briefing papers. This record is quite voluminous. Summarizing that record could not have been easy. The OAG truly appreciates your efforts. Similarly, the OAG appreciates the ALJ's thorough analysis in this case. The ALJ's conclusions support many of the positions advocated by the OAG in this proceeding. Most importantly, the ALJ found that the record supported that Xcel failed to prove it operated and maintained Sherco 3 in a reasonable and prudent manner consistent with good utility practice, that Xcel had and took the opportunity to pursue redress against GE, that Xcel owes its Minnesota ratepayers a refund of all imprudently incurred replacement energy costs, and that Xcel is not entitled to any offsets or credits against replacement energy cost refund besides the 24.4% allocation of the GE settlement amount agreed to by the interveners. The Commission should now find that the application of tort law principles is irrelevant and inappropriate in a utility prudency review. Such a finding would give the Commission reasonable grounds to depart from the ALJ's recommendation and order a refund of 100% of the replacement energy costs incurred rather than just 48%. After all, the critical issue in this proceeding is whether it is just and reasonable to hold ratepayers who had no control over the incident at Sherco 3 responsible for the catastrophic failure, and the costs incurred. Xcel chose to use a GE product at Sherco 3. Xcel chose to ignore its own engineers' warnings of potential catastrophic failure. Xcel chose to install discretionary upgrades instead of conducting prudent maintenance. Xcel was the only party in this proceeding entitled to seek redress against GE. Xcel had its day in court, it had its chance to recover its costs, and it chose to settle with GE. Should the Commission decide to order less than a 100% refund of replacement energy costs, whether by virtue of the ALJ's recommendation or by adopting any of Xcel's misplaced offset proposals, the Commission will be holding blameless ratepayers responsible for Xcel's actions. But the Commission can and should avoid such a result. The Commission should find that Xcel's imprudent maintenance caused the catastrophic failure of Sherco 3, and that by extension all replacement energy costs incurred were imprudent. The Commission should order a 100% refund offset only by the 24% amount discussed of the GE litigation settlement and adjusted with interest as calculated by Department witness Mr. King. And in terms of decision options, the OAG supports 2, 4, 6, 7 or 8, 9, 14, 16, 19, either 20 or 21, 22, and 23. Or 24 and 25. We're comfortable with those as well.
22 or 23 and 24 or 25?
I believe it's 23, 24, or 25. We think they all get us to the same place.
And can you start up to 14 again, starting with at the beginning?
Certainly. So 14...
No, sorry, starting before that. Like at
oh,
1.
sorry. We support decision options 2, 4, 6, 7 or 8, 9, and 14.
Thank you. And finally, we have the Department of Commerce. Mr. Mertz, good morning. Please state your appearance.
Chair, Commissioners, Greg Mertz, Assistant Attorney General, representing the Minnesota Department of Commerce. The Department very much appreciates the careful and thorough review by the administrative law judge of a very voluminous and complicated record, and we also appreciate the hard work of your staff to summarize that record. We don't agree with everything in the ALJ report, but we do agree with the extensive findings that establish Xcel's lack of prudence in its operation and maintenance of the Sherco 3 plant. In this case, as I think everyone's acknowledged, Xcel has the burden to prove that it acted prudently. Not only did Xcel fail to carry that burden, the evidence actually demonstrated exactly the opposite conclusion. In ordering this matter to hearing, you said utilities are expected to act prudently to protect ratepayers from unreasonable risks. Xcel did not do that here. That's a conclusion that's fully and completely established by the record. It is particularly shown with respect to Xcel's decision to defer a major inspection that would have happened in 2011, right before this disaster, in favor of other non-essential work that they did at the plant. One aspect of the ALJ's recommendation that we don't agree with, and it won't surprise you to learn, is we don't agree with the apportionment of responsibility to reduce the refund to Xcel's customers. Contributory negligence, whatever GE did or didn't do, doesn't play any role in a prudency proceeding. And a couple of the cases that your staff referred to us last week reflect that legal conclusion. This approach was not something that any of the parties advocated, and so it came, frankly, to us as a surprise. It's not something the ALJ had the benefit of parties' arguments about. It's important to remember, as I think our other interveners have noted, GE is not within this commission's jurisdiction. It's not before the commission in this action, and Xcel's ratepayers can't look to GE for a refund. If it's your determination that we should reduce the refund by some amount of negligence or fault attributable to GE, then that means that ratepayers are the ones that end up being responsible for that. As has also been noted, GE brought a lawsuit against Xcel brought a lawsuit against GE to get compensated for what it claimed to be GE's fault, and it settled that suit and by definition accepted that amount as reflecting GE's financial responsibility. Rates must be reasonable. That's the law. And if they include costs that are incurred imprudently, then they are by definition not reasonable. If you were to accept Xcel's argument here, you'd be setting up a situation in future prudency cases where the utility is always looking for a third party to blame. And that would not be an outcome that would be favorable for the state of Minnesota. Turning now to the calculation of refunds, our approach is very simple, very straightforward. We accept the calculation that Xcel did in the GE litigation. We add to that interest at the prime rate, which I think everyone agrees, and then we credit approximately 24% of Xcel's settlement with GE, including an adjustment to reflect when that money was received by ratepayers. So turning now to the decision options, the department recommends the commission adopt 2, 4, 6, 7, and that includes subparts 8 through E, 9, 14, 21, 26, 19, 20, including subparts A through E, subparts A through H, and then 25. In addition, I just want to observe that the RUD has also proposed certain language to be adopted that kind of parallels ours. From our perspective, you can adopt either our language or the language recommended by OIG. You end up in the same place. So I just want to make sure that you understood we weren't opposing that language.
You lost me after 14, so
Okay.
I apologize.
14, 16, 19, 20, and 25.
25, okay. Thank you.
I wrote down 21 and 26. I think you said that, but I don't know if,
Well,
I'm not
I just
looking
have,
at
I
it,
just
so
have
I don't,
25.
so it's 14, 16, 19, 20, A through H, and 25.
That's correct.
Okay. Okay. Thank you, Mr. Mert. So, Commissioners, I was thinking that we would start first with questions around prudency. And if Commissioners have questions around that for the parties, I'd encourage you to go ahead and ask. And then that seems to be a bit of a threshold question in my mind, the way I was thinking about this. And so we could, if we're ready, then take a vote on that, just on that issue of prudency, and then proceed from there. So who would like to begin on questions of prudency? Anyone? Any questions? Then, Commissioners, do you, I don't want to rush anything here, but is anyone prepared to move into deliberations just on the issue of prudency? And I think it's pretty clear where the parties are, but Mr. Long, just because you didn't state your explicit decision options, will you, I assume you conclude you're supportive still of number 3, is that correct?
Yes, Chair Sieben, I'll note that the staff briefing papers, I think, accurately reflect our preferred decision options. We're also comfortable with decision option 25, which is a staff proposal.
Okay, great. That's not on the issue of prudency. So, Commissioners, if there's no other discussion and or questions, I am supportive of decision option 4. Agree with the ALJ, the department, the Office of the Attorney General, and the XLI that Xcel failed to operate and maintain Sherco Unit 3 reasonably and prudently and in a manner consistent with good utility practice. That would be my motion. Is there any discussion of it?
Yeah, Madam Chair, I looked through the record closely, and I don't think there's anything that changed after we sent this to the Administrative Law Judge. I think the Administrative Law Judge on this question did a thorough job, and so did the parties, so
So you support my motion?
I do.
Any other discussion? Hearing none, then we'll proceed to vote on decision option number 4. All in favor, please say aye. Aye. Opposed? The motion prevails 4-0. Okay, then, if we want to continue in the way that I thought about this, we don't have to. But I was thinking next that jumping ahead to the overall we could next proceed to questions on the issue of the percent of the recovery attributable to Xcel. There is a disagreement here, as our staff laid out clearly, between the ALJ and some of the parties. Some of the parties did mention the case law that was cited in the information requests that our staff sent to the parties. And so maybe my first question will be to Xcel on the case law that was cited from other utilities around the country or utility cases around the country. Did you have any comments or reaction to that specific case law, Mr. Harris, that you wanted to share with the commission?
Yeah, Chair Seaman, just a couple reactions. First, in response to the questions that we received, is there sort of opposing case law from around the country? We did some research and found a couple of cases. We can provide the sites, though I don't think it's particularly important to do that. They're from Oregon and they're from New Hampshire, that showed that in prudency reviews in sort of fuel-related cases, that sometimes manufacturer error was found to be a reason to not require a refund from a utility. But the really macro point that I want to make on this, if you sort of look at the specific cases that you're talking about, what I found notable in each of them is two things. One, in all of those cases, and it's really expressly stated in the Texas case, which I think is the Nucor case, the plants that were, in outage remained in base rates. And so then what you saw was commissions wrestling with, okay, well, this plant's in base rates, customers are paying for that in base rates. How do we deal with the fact of additional replacement power costs on top of that? And that gets to sort of that second point where they said, look, if this was a manufacturer error, if this is something that was a problem that was caused by a third party, we're going to lay that at the feet of the utility to go and deal with. You can go and hold those companies responsible by suing them. And I think that that's a pretty different procedural posture than we're in this case, though you can do things to essentially get to the same outcome as those cases if you wanted to. Because what we've done is we did go and sue GE and we provided those funds back to customers. And so this is not a situation where we're suing them and we're able to retain that money for ourselves, just the risk of the replacement power on top of it. Mm-hmm. And the second is that, in the 2012 rate case, our plant was pulled out of base rates, both the O&M costs and the sort of the carrying capital cost was pulled out of base rates. And so, we weren't in sort of that same situation where the replacement power is truly something that's on top of what customers are already paying for, what the commission viewed as a reasonable cost of service. And so I think if you back those two things out, then you functionally end up in the same kind of position that the commissions in those cases that the commission cited to were in.
Could you give us a citation for the Oregon and the New Hampshire case?
I can. Just bear with me 1 second here. So the Oregon case that I'm referring to is Matter of Pacific Corp doing business as Pacific Power, and it's Oregon PUC docket number UE191, order number 07446. I'll give you a Westlaw site as well. That's 2007 WL 3091578.
So not a court case, but a...
Not a court case. Both of the cases that we found were at the PUC level.
Okay.
Well, all three of the cases. The other two cases are essentially related to the same issue from New Hampshire, and that is Ray Public Service Company of New Hampshire, docket number DR 91011, order number 20,280, and the Westlaw site for that is 1991 WL 494456. Which part? The whole thing? Yeah, so the Westlaw site is 1991 WL 494456. And then there's a follow-on case to that, same title of the case. The docket numbers there are DR 92050 and 92165. The order number is 20,794, and the Westlaw site is 1993 WL 475224.
Okay, thank you very much. Mr. Mertz, did you comment on the case law that the staff put into the record in your opening statements? I can't recall.
I have not
Could
yet.
you please just, if you had any comments, it'd be helpful.
I appreciate that. It's not going to surprise any of you that I read those cases radically differently from the way Mr. Harris is reading them. What I see those cases as standing for is the proposition that a utility can't avoid its responsibility to operate its facilities prudently by pointing to some other third party. That's what all of these cases are about, and I appreciate Mr. Harris's close reading of them, but I see these cases as, if not perfectly on point, very close to that. And I think if you look particularly at this Long Island case, no, I'm sorry, is it Long Island or Texas? The Long Island case. In that case, what the utility was claiming was a bunch of stuff, but one of the things they claimed was that a vendor had misled them about the capabilities of a particular piece of equipment and then misled them and covered it up. And so it's really very similar, I think, to the story that Xcel has been trying to tell about GE and its role in this catastrophe. I can't comment on three cases that I've never heard of before. We did do some amount of research to find opposite cases, didn't find any cases that came out the other way. Be happy to look at these to the extent the commission thinks that they want to rely on them, because I would like an opportunity to say something about them if they become important to this decision. So, thank you.
And Mr. Murray, any comments, further comments you wanted to provide?
Yes, thank you, Chair Sieben. Just briefly, probably to no one's surprise, we also support the reading presented by Mr. Mertz. We think it's especially clear in the Pennsylvania and Louisiana cases that ultimately the utility is in the best position to pursue redress against the any third party, whether it's a manufacturer with a design defect or a vendor. Ultimately, the utility has to hold that party responsible. Holding any otherwise would leave ratepayers exposed for situations they had no control over. Then we also noted in the Texas case, it pretty soundly rejects the idea of applying tort law principles to utility prudency proceedings. So we think that's really important given the nature of the ALJ's recommendation for a refund in this case.
Thank you. And Ms. Lee, I think you said that this is the one area that you departed from the ALJ's recommendations. Any further comments on the case law that was cited, or other comments on this percentage of recovery attributable to Xcel?
Yes, thank you, Chair Sieben. Wholeheartedly agree with the department and OAG's assessment of this case law. There's nothing in these cases that says that stands for the point that Xcel would like to make, where GE should be responsible for some of these imprudently incurred costs. And I think the OAG is right to point out the Nucor Steel case, which says exactly that. The law that guides utility rate making and fuel cost recovery is very different than tort law, and it makes sense that they're very different. Thank you.
Commissioners, do you have additional questions in regard to this section, which would be 17, 18, 19, or 20? And who are you pointing at? Commissioner Means. Sorry, I didn't see your hand.
I
Kind of hide
didn't.
behind Wick one.
I don't know, Chair. I guess I would want to have a moment to review the cases that were cited by the company.
Okay, we can. So we could. How much time would you like for a recess?
15?
No problem. The commission will stand in recess until 5 minutes to 10,
And Susan,
or
do you-
5 minutes till
have them,
10.
or-
Yes, is that 15 minutes?
Can you email them around or?
Just if that wasn't caught on the mic, Commissioner Tuma asked that the case law that was, or the cases that were cited by Xcel be emailed to the parties and the commissioners. So maybe we'll just call it 10 o'clock. That will come back from our recess. The commission stands in recess.
Chair,
Oh, sorry, before we do that,
I'll just
Mr.
note that
Harris.
the cases are somewhat long, as you can imagine a fuel clause case might be. I'm going to look and see if I can find a pin site for all of you to look at, so you're kind of focused on the relevant portions of them, so you're not just weeding through, if that makes sense.
That would be helpful.
Yeah.
You're going to look
I
for
was-
that now, Mr. Harris, or do you want to? Okay, we'll just.
I joked it was like going back to law school. This got like in the nutshell. Remember that? You know, the little nutshells that you used to get? Okay.
I'll note that the Pacific Corp case.
Oh, Mr. Harris, I'm not sure your mic is on.
So the Pacific Corp case, I don't have a page pin site to, but it's in section B. 2D. And the first of the New Hampshire cases is discussed at looks like page 13 of the Westlaw copy. And the second, I also don't have a specific pin site to, but it's in section 2, it's like 1C.
And Mr. Harris, maybe you already said this, but I need it one more time. In those, the three cases you cited, did the commissions in those cases make a finding of contributory negligence? Not necessarily. Is that?
They didn't make a specific finding of contributory negligence. What they found was that the fuel cost, like sort of the replacement power costs, were caused by manufacturer error and therefore were not attributable to the imprudence of the utility.
Okay. Very good. We will stand in recess until 10 o'clock. And then, commissioners, I'm on the struggle bus a little bit about deliberations here. If you're comfortable, or you can think about on the recess, if you want to make a decision on this section, we can do that when we come back, take a vote on it, and then proceed. Then my thinking was we'll just start from the beginning of the decision options and move through those sections in order after we. But if any commissioner is not comfortable making a decision on this section, then you're welcome to say that and we can change the plan. But that was sort of what I was thinking would work. So the commission stands in recess until 10 a.m. The commission will come back from its recess, and before we go to commissioner questions, or I'll start with a question. Mr. Mertz, I'll begin with you. Did you have any reaction or time to look at the cases that were cited, and do you have any comments on them?
Thank you, Chair. I did look at them really quickly. I can't tell you that I had time to fully digest them. I did not see in those cases anything that I thought, oh my goodness, that seems to be inconsistent with our position. I just didn't see anything like that. Maybe there's something in there and maybe I missed it given the amount of time that I had to look at it. That's certainly not beyond the realm of possibility. The other thing I would say is the position that we're taking here about this reduction is really the one that's consistent with the way Minnesota has handled these kinds of cases, these prudence cases. And the commission has emphasized that utilities need an incentive to make sure that they're providing safe, adequate, reliable service to their customers. And to the extent that you are going to let Xcel, or any other utility for that matter, avoid that responsibility by pointing to somebody else. I mean, think back to the case we were here last week on. Are they going to be now claiming that their responsibility should be reduced by whatever negligence they say their contractor is responsible for? They are the ones that have the responsibility to ratepayers. GE doesn't have that responsibility. And so they're the ones that we need to hold to that responsibility. And so whatever the cases that were revealed this morning say, I don't think any of that changes how this commission has approached prudence and reasonable rates.
Mr. Murray or Ms. Lee, any additional comments you'd like to provide on the cases that Xcel just entered into the record on?
Yes, thank you, Chair Sieben. Like Mr. Mertz said, we didn't necessarily have time to fully digest the entirety of the cases. We do agree that the overall position of Minnesota in treating utility costs is protecting the ratepayer. We don't think what we've seen in these cases cited by Xcel doesn't change that. We'd also note that these cases, it was acknowledged, but just emphasizing the fact that these were not cases that had the benefit of any level of appellate review. So they're persuasive, just like the cases the commission identified in this proceeding. But those cases at least all went to the New York State Supreme Court or an appellate court. We think that's an important distinction. We also noted that at least in one of the New Hampshire cases, there was no finding of imprudence, which is a substantial distinction. And the outage in the Oregon case appeared to only be 7 weeks long, so a much different circumstance than an outage lasting nearly 2 years. Thank you.
And Mr. Harris, tell us again why you think the Oregon case is relevant here.
Yeah, Chair Sieben, all that I'll say is that we looked for, were there other cases where a vendor was found, to be responsible for an accident or an incident, and that impacted the commission's decision on, whether they were going to find imprudence or whether they were going to have a disallowance in a case. I'm not trying to suggest that this is like the greatest authority in the world on that. It's just that there is sort of a mixed bag that you see in in cases from PUCs around the country. One thing that I'll note though is that if we're talking about contributory negligence, because I don't think that these have anything to do with contributory negligence, but I do want to correct the record on something that I heard earlier from the department saying that, look, no party advanced any argument about contributory negligence here. This is really something made up by the ALJ. That's just not true. Both the department and the OAG previously advocated that in January 14th, 2019 letter and a January 31st, 2019 letter in this docket.
Would they tell me a little bit more what happened there? The department argued that there was contributory negligence, or I didn't follow that.
They said take the jury finding here and use that as a basis for coming up with the right replacement power amount to be refunded.
Amount or percentage, or either one?
Either. Using the percentage.
Mr. Mertz.
Thank you. What happened in that case is the department initially took the position that the commission should order a refund based on what the jury finding had been in the GE litigation. 2 weeks later, The department said, no, we're not taking that position anymore because we agree with OAG and with Xcel's fallback position that this should go to a contested case proceeding. And so the fact that the department's position changed is of record. It changed, and they said, we no longer are advocating that perspective. So it's a, and then it was actually a couple of years later before the commission ultimately referred the case for a contested case proceeding.
Great, thank you. Mr. Murray?
Thank you, Chair Sieben. I would also like to point out, we think it's extremely important for the Commission to recognize that what the OAG said in the January 31st letter, and I quote,
January 31st of what year?
2019.
19.
The OAG supports the department, and that's the portion that is referred to in Xcel's reply to exceptions. But what the OAG said in full, the OAG supports the department in both the principle that Xcel should reimburse ratepayers for any portion of the costs that resulted from negligence by the company, and that the company should be required to provide a detailed accounting of additional information related to the Sherco 3 failure. That said, and this is all in the same paragraph, that said, the civil process should be allowed to run its course so that the Commission and other stakeholders have the benefit of the complete record in those proceedings before making a decision on how much Xcel should be required to refund ratepayers. So it is not accurate to say that we supported the 48%, 52% recommendation. We only supported the idea that Xcel should refund its ratepayers.
Commissioner Tuma?
Yeah, Mr. Harris, I look at you're kind of in a difficult position, and I appreciate that, because you have done, I think, some very important right things after the imprudency, and so I'm working from our decision now, and we don't have to go back to the question of where imprudency occurred and that, and so the struggle is we had a facility at a major catastrophe. Thankfully, nobody died. Okay, that's important. You guys did a good job in recovering from that, and I think did a lot of the right things going forward. It's how we build it into the regulatory structure, and so I could see theoretically, okay, that once we found imprudence, the question is how much is recovery. That was the very same argument we had, I think, with I believe Monticello. I struggle with that. That was one of my first big cases here. You're imprudent, all of it. And the department at that stage argued, well, after you get past the imprudency, you do have some broad authority, okay, that we can determine how much should be recovered, whether the company acted in good faith, and the decision we made at that time was to deny you return on the facility. This apportionment question, I think, really is a sideshow for you, okay? The judge following into the jury's, using the jury's apportionment somehow to divvy up theirs could arguably be a legislative decision she was making, not a judicial decision. And you're it wasn't your argument, but it's there, and you're grabbing onto anything you have. That's what I see. Correct me if I'm wrong.
Mr. Harris?
Chair Sieben, Commissioner Tuma, you're thinking about it almost exactly the way that I think about it, but I'm going to note that I don't think we actually grabbed on to the apportionment argument here.
It's so just there.
I think about this as, she looked at, and this isn't stated in the order, but it's sort of how I've interpreted it. She found that we acted imprudently, but when you kind of look at the evidence, it's a close call on whether we were imprudent here. And so thinking about quasi-legislative authority, did that kind of apportionment. My only sort of what I would say is reaction to that is I think that there's a better way to deal with that quasi-legislative authority, and I think that that's looking at the offsets that we've talked about from the GE litigation and from the prior rate case disallowance, which I think provides a much more record-based and rational way to get to sort of a right number.
I think that's the struggle I have. To me, we made a decision on the rate base issue. That was litigated theoretically all the way through. You didn't appeal us. You didn't challenge us. It was done. The litigation that we brought, okay, and that you brought to GE was for a little bit of some costs, if I remember, it was like 5% of some other costs, and then replacement energy. And to me, that's the bucket we're dealing with right now. To expand it beyond that seems to be somewhat inappropriate. We're dealing with replacement energy costs. If I remember, and I had to go back, I wish we went back and looked at the tape. It was Mr. Mertz over here that made it very clear to us, this litigation that we're referring to the ALJ is replacement energy costs. And you in some ways to their benefit, but you were saying that's what we're dealing with. When we go to the ALJ, it's replacement energy costs. So to bring up the base rates adjustments and the other things that you've done, all good, we should say, yes, thank you. That should factor into our legislative decision, okay, whether all the replacement costs or some of the replacement costs or whatever we make a decision on should be done. That's a factor that we can put in there, but I don't think it's determinative here because it wasn't a question about how much of this should be used to reimburse you for the facility being not used and useful. And granted, that is distinguishing from the other cases, but it is a separate rate-making principle to the question of replacement power. That's how I'm seeing it. So correct me of my ill-conceived view of what was actually in front of us today.
Chair Sieben, Commissioner Tuma, I think you're right that it's a different rate-making construct that comes up in the rate case. But the real question, I think, when you're dealing with the quasi-legislative authority is, and this is really consistent with parties' positions previously in this case, is what's the net harm to customers coming out of this event? And I think that really plays into that quasi-legislative question that you've got. And when you think about what's the net harm to those customers, if you look at 2013 specifically, and we briefed this up, and I'm sure you're familiar with it, if you look at 2013 specifically, customers didn't pay for any costs related to the plant. It's undisputed that was a $21.6 million disallowance to the company in that case. They did pay $20 million worth of replacement power in that period, but those two really function very naturally as an offset. Replacement power really is power, costs that you're incurring for power above and beyond what the normal cost of running your system is. And here, the normal cost of running our system had already been deducted by that $21.6 million. And so that offset, I think, is critical to be factored into that net harm question in the replacement power calculation that you're doing.
And this is a struggle I'm having, Mr. Mertz, or to the OAG. I mean, it seems to me that a plant not used and useful we shouldn't be paying for that if it's not used and useful. We're also paying for replacement energy. They seem to be two different things. You're the one that told us this is about replacement energy. Let's focus on that. I don't think they should be intermingled here, and I guess I just want to hear that's why you did what you did.
Well, that's exactly it. There's very good reasons for making sure you're treating these various buckets of cost separately. You don't want confusion about kind of the outcome. You don't want inconsistent outcomes. You don't want double counting. And so for that reason, you did, I think, keep separate power replacement costs from the restoration costs from the fuel oil costs because different streams of money were coming in and going out. And so I did tell you that this should be limited to power replacement costs, and I think the Commission appropriately set that as the scope of this case.
And so I'm looking at the legal standard, and obviously our staff struggled with this. What is the appropriate legal standard going forward given the ALJ's finding? And so I can find it somewhat useful that the ALJ maybe found that there should be a write-off or deduction or for other events that occurred. So she's exercising what I believe a legislative authority here, not a legal authority. When I looked at the case law, and particularly the Pennsylvania case, but I think the Long Island case was instructive. I think they all were very instructive, but here we had the Commission is determined to be the expert body in charge of the legislative function of rate making. And that's is making it very, very clear that this is not a judicial tort type process. It's a completely different construct. And the regulatory compact guarantees a rate of return, and the customers bear that cost on a fair rate of return, and also for just and reasonable rates. That's that regulatory compact that goes in there. The utility bears the burden of establishing that the rates are just and reasonable, which is totally different than the tort setup. And actually, again, I went back and looked at the tape, and Matt Harris on June 23rd, 2022 said, however, following the trial, which we did not participate, the department recommended that we disallow a further 19 in replacement power costs. That recommendation was based on a legally irrelevant apportionment recommendation of fault by a jury in that case. And so you agree with us. We're here in the regulatory construct and trying to figure out what's a fair rate of return. In order to find just and reasonable rates, the utility must prudently incur expenses. Did the utility act reasonably under the circumstances, recognizing the company has to solve problems prospectively? We can't go back and play, I think it's very clear through these cases, we can't play Monday morning quarterback and say, oh, the perfect person would have done this knowing all these facts. We have to assume looking forward, and we made a determination in this situation that you didn't act prudently, and I think there's plenty of things on the record. The utility cannot contract away their obligations to operate a utility prudently to a third party. And I think that is the central focus of the cases that we looked at here. And that's where having a legal debate here, when you look at the case, particularly the New Hampshire case that you cited, New Hampshire said, look, Yankee, you performed prudently. Some third party didn't act appropriately, and you're suing them, good for you, but because the ratepayers have a relationship with the utility, and the utility was prudent, therefore we're not going to deduct it at that situation. One could have a debate that maybe Pennsylvania disagrees with that. And this is what the Pennsylvania case says. We believe a utility company is in a better position to prevent an occurrence or provide for protection against any such occurrences dealing with third parties. After all, it is the utility which chooses the contractor, negotiated the contract, and is in the position to seek damages for the losses sustained under the contract. Well, the utility may have to bear the initial losses incurred as a result of its contractor's negligence. It is in a far better position to aggressively pursue the tortfeasor for reimbursement. If we were to hold otherwise, the utility would have no incentive to pursue the tortfeasor, having already received full compensation for its losses. And so, to me, that's what Pennsylvania case is trying to say, and I think where we struggle with how the ALJ has given us an order here, that this is the regulatory compact under which we sit under. Actually, what I found extremely interesting is the Texas case. That was after deregulation, if you remember, and they actually had to go back and point to the fact we're not under the deregulation statute here. This is an issue that happened before deregulation. We're back in the regulatory compact, and so we're under the regulatory compact, Minnesota. We buy into it. You've bought into it, and so it seems to me that one could make an argument if you hire a third-party contractor who is negligent. Maybe we could hold you as imprudent, even though maybe all your actions were prudent. That's not the case here. We're not deciding that. But it's clear that the way the Pennsylvania thing set it up is that you bear that initial cost. Now, I think you have to read this, too, with 9, 10, and 11, that if we are going to set up this regulatory compact, we have to read it with the fact that if you do expend money and provide it to ratepayers and then aggressively go after it and get it back, that should really belong to shareholders at that stage. And so that's a future debate. So I don't want to miss that. There shouldn't be a double recovery. But it seems like the structure here is we have now a legislative decision to make dealing with this question of what should be prudently incurred. Did you act prudently in going after that money? Yes. Did you settle prudently? I thought your settlement was wise given what happened. So all of those are wise, but then your shareholders should gain that benefit from that aggressiveness. And so I think that's what the Pennsylvania case is saying, is that, yeah, you may have to carry some burden that might not be yours, but that's also to incentivize you to do the aggressive thing. That's how I'm thinking about it, but I want to give you a chance to correct my misreading of the law.
Chair Sieben, Commissioner Tuma, I think about it really similarly to you, and that's what those cases are standing for. The one, you said two things. Well, you said one thing that stood out in my mind, and there's a quote from one of the cases that I want to bring up. You noted that the sort of regulatory compact involves customers paying for a return on the assets that we've invested in. And in exchange for that return, we're taking on the risk of operating the plants. We're taking on the risk of replacement power. But that's not what happened here, right? In 2013, we did not receive a return. The customers did not pay a return for the plant, and I think that that's a really salient fact. And when you're engaged in your quasi-legislative thinking on this, and it's really consistent with the Nucor case from Texas, and I'll just quote from that case, which says, TXU should not be allowed to recover the replacement fuel costs because the rates paid by TXU's customers during the outage included a return on the utility's investment in Moses 3. The Commission reasoned that TXU customers should not be required to pay for Moses 3 during the time it was not generating and be required to pay for the replacement fuel costs. This is just the inverse of that, right? Like, we didn't earn a return. Customers didn't pay a return on Sherco 3 while we were incurring the replacement power costs here. And so to allow both the recovery of replacement power costs and have that disallowance hit is effectively a double counting in favor of customers.
We litigated that question of base rates already, and that's the part I'm struggling with. We separated it out. We addressed it. We dealt with it in a rate case. Just because Texas did it this way doesn't say that ratepayers in Minnesota should also pay for a rate of return for a facility that's not operating for a couple of years, and also pay for not have to then pay for replacement power. I don't know if that's what that case is saying. It just says that it exists in this situation. We litigated that one, so I mean that's the way I see it. I want my other attorneys to correct my reading of the law, because I want to apply it correctly, that I'm now dealing with this from a legislative standpoint in trying to determine what is a fair cost of recovery for the ratepayers versus the shareholders here, and that the Pennsylvania case seems to indicate that it's at most to motivate them to do an aggressive job.
Thank you, Chair Sieben. Commissioner Tuma, I would say that pardon me.
Sorry to draw you down into my Allison.
No. I just completely lost the train of my thought. Could you maybe give me the synopsis of your question again? I heartily apologize.
This is where I'm struggling with, is that I've gotten to the point where they're imprudent, okay? We've accepted that, and now it's a question about what is the appropriate regulatory structure. I think the best regulatory structure is the Pennsylvania approach, okay? And that is you carry all the costs, okay? We kind of muddled that up by making them refund the litigation, but you carry that cost so that you aggressively go after that money. And that's the regulatory construct that I think that makes sense. Now, inversely, that's why I don't want to trick you into thinking that this goes to number 9, 10, and 11, If we were to follow the Pennsylvania case to its fullest, okay, and its theory of regulatory structure, they're taking on some liabilities of third parties that they could go after aggressively, okay? And so therefore they should be entitled to all of that refund. That's the kind of way the Pennsylvania case seems to set things up in my mind. And I want to make sure I'm tracking with that, because I think it now that we're in this legislative question about how much should they appropriately be recovering, we got past the legal hurdle. Now what is appropriate in this situation? And I like the way the Pennsylvania case says it's pretty solid. There's imprudence, even imprudence to your third parties. You cover it, utility, and then you go after all those other tortfeasors aggressively because you've got shareholders that are chewing on you. That's the way I see the regulatory construct. I'm worried that we're creating something different with the way the ALJ set things up, and I'd rather fall into the Pennsylvania approach. How much of it is still to be determined, but I like the Pennsylvania approach, and I think that's the way the commission should go, but I want to make sure I'm seeing the Pennsylvania approach correctly.
I guess what I would say is I'm not certain that you're seeing the Pennsylvania approach correctly. What I would say, and we've said this before, is that that settlement with GE that came from effectively ratepayer funds. Ratepayers paid for this plant, and it was appropriate for that settlement to be returned. Now, how much of it was restoration versus replacement cost? That's what this fight is about, obviously. But I don't think that the fact that they pursued this litigation meant that therefore they get to keep the money. I don't think that's an appropriate result here.
And I don't think that's what the Pennsylvania results would say. Pennsylvania would start off as, you don't get any of the money, okay? And you have to come to us and prove to us you're entitled to it. And oh, by the way, any litigation that you succeeded at third-party tortfeasor, you get to keep. So in other words, replacement power they shouldn't get any of it. And because they were imprudent and their third party was imprudent, that they should have looked after. That's what I think it stands for, Pennsylvania. And therefore, none of it. But you should then get to keep whatever you aggressively get out of the tortfeasors. I think that's the construct that Pennsylvania gave us. We kind of muddled it up by ordering a refund, and then we have an ALJ giving us this 5248 finding or whatever the number was. And I think that just muddles it up. I just think Pennsylvania's approach is much simpler, and I think we can unravel this particular situation to mimic what Pennsylvania done.
Yeah, and where I would come back to is I think where I started a couple of years ago when we got on this path is that it's appropriate to keep the restoration costs separate from the replacement costs. And if you are giving Xcel credit, it has to be credit that is appropriately related to replacement power costs, not some other costs.
And that's what we specifically sent to the ALJ. There was no argument over any other things because we sent to the ALJ simply the question of replacement power. So, yeah. Madam Chair, I want to give my other two attorneys who are in front of us a chance to correct my thinking, but I think I know where my brain is at.
Mr. Murray?
Thank you, Chair Sieben, Commissioner Tuma. We generally support the position expressed by Mr. Mertz. We think it's also worth pointing out that the settlement that was refunded didn't only cover replacement power costs. There were restoration costs that were not covered by insurance. So we think that's an important point to consider. And just as a general policy decision, allowing Xcel to relitigate something that you very clearly said was decided, it risks putting ratepayers in danger and kind of contravening what we're here to do.
Ms. Lee?
Thank you, Chair Sieben, Commissioner Tuma. I think I agree with Commissioner Tuma. This is the regulatory compact that we're under, and I think the ALJ's opinion, except for the contributory negligence finding, divvies it up exactly right in that the rate case disallowance, the rate base disallowance is not replacement power. And the portion of the GE settlement, I think all of your interveners agree, that should be credited back to Xcel. So the buckets are very precisely dealt with, I think.
I have enough questions for now. I do have some more questions. We get
Yeah.
the other stuff with the decision options, but I'll wait on that.
Okay. Commissioner Hahn.
Thank you, Chair Sieben. I have a little follow-up to the discussion on the disallowance. I think, as Commissioner Tuma said, it's already settled. If you want to reopen that one, so I have some question. It's a hypothetical question. I'm not going that route, but whether that ratepayer harms are properly reflected in that discussion. That is, Xcel had a 2010, 2012, 2013 rate cases, and then disallowance happened in 2012 with the test year 2013, and then Xcel filed 2013 rate case and recovered this cost from 2014 test year, right?
Chair Sieben, Commissioner Hom, we, in the 2013 rate case for the 2014 test year, we then were recovering sort of the full balance of plant, the O&M associated with the plant at that point in time, and the return on the plant. There was a deferral of the plant costs, of the depreciation costs from 2013 into those future cases, but I don't think it was making up for the disallowance that occurred in the 2012 case.
I understand. So my concern is the 2010 rate case, you have received O&M cost for the 2011 test year, and you were about to do maintenance for the Sherco 3. I don't know whether you properly spend that money because you skip turbine inspection. So I don't know. I do not review the whole record. That's a potential harm to the ratepayers because you are allowed to recover their money in 2011 and you didn't spend. That's a real harm to the ratepayers. For the 2012 rate case, you are disallowed for the 2013, but Mid-Continent ISO capacity market runs over 2 years. So planning year 2013, 2014, you were not able to offer this capacity to the MISO capacity market because of the capacity market accreditation done prior to March of that year, 2013, and then auction happened in the May of that 2013. So you were not able to offer this capacity.
So, Chair Stephen, Commissioner Hom, I think there's a lot built into what you just talked about, and I'm going to get over my skis when we get to the capacity market piece of this. So I'm not going to really try and engage in that, and potentially we'll bring somebody else up to talk about it. But I want to engage on that question that you had about the 2010 rate case covering the years of 11 and 12. Most notably 2012, which is sort of the first full year that the plant was out. I think you're right in thinking, boy, could there be a ratepayer harm there if we're recovering too much in O&M costs, if we're recovering too much for that plant that year. But a really important fact that shows up in our jurisdictional annual report for that year is that when you look at what the authorized return was that we had sort of as a whole, which was 10.37% at that time, our earned ROE for 2012 was 5.73. And so obviously there's a lot that goes on in a rate case, but I think it's pretty hard to say that customers were overpaying for our plant as a whole at that point when you look at sort of like what is that cost.
I understand. That's why there is a potential Xcel was trying to save money to give ratepayer, the shareholder more money because you are not getting your goal. So that's why you keep filing rate case. That's a signal that you are not getting the money you want. It's not that what commission approved and party agreed. So you may skip O&M. So you skip certain maintenance to save money for the shareholder. That's why that's the potential harm, not the overall rate case. I'm focusing on specific items. So for example, you can skip the vegetation management to save money so you can increase rate of return. That's very dangerous. Same thing. If you skip maintenance of the power plant to save money for the shareholder, that's very dangerous. So that's why I say I didn't review the whole record, so I say it's a potential harm, but this is a clear record. Xcel cannot offer this capacity in MISO capacity market for the 2013-2014 capacity market, right?
Chair Stephen, Commissioner Hom, I'm going to I'm gonna ask Mr. Krug to come up here and answer. We did look into sort of the capacity position of this and hope we can actually answer your question.
Mr. Krug, welcome to the commission. Please state your appearance and then
Thank you.
proceed.
Can you hear me?
I can, but
Okay.
The camera's not going to you, so I
the
don't know.
people in the back are thumbs up, but
It says it's on. Should I switch to you?
Oh, there it goes. There it went. It just was.
Okay. Is that better?
I think
it
Mary's
is,
trying
but
to
now
keep
the
big camera off your face. I don't
the
know.
camera does not track as well as our lately in that corner mic. So if you could use Mr. Swanson's, it might work better. Sorry. We don't need to look at me. We want to look at you when you're speaking.
Thank you. So I can hear it now. Thank you, Al Krug with Xcel Energy. I'm not camera shy, by the way. So, first of all, I'm not necessarily an expert in the MISO capacity markets. Certainly, Commissioner Hom has more experience in this, but I did look into this specific issue, trying to anticipate potential questions. So at that time, just to start at the beginning there, even including the outage at Sherco and our inability to offer it into the market, we had sufficient length. So we certainly didn't have to, at that time, we did not have to purchase any capacity, and certainly customers did not incur any costs related to that. To your question about whether we were restricted in offering into the MISO capacity market, it was my understanding that the formal market began in 2014, and by then our unit was available. Prior to that, capacity was bought and sold in by bilateral contracts. The market was, since the whole MISO footprint was very long at that time, there was de minimis ability to offer the unit, and so I would say the outage itself had very little impact on our ability to either earn any additional revenues at that time.
Okay, thank you. So after that, the MISO accreditation usually use this forced outage as a penalty. And a minimum 3 year post this incident, there's a potential derating of this unit for 2015, 2016, and 2016, 2017, and 2017 and 2018 planning year.
Mr.
Commissioner
Krug.
Hom, I would have to go back and check that. It was my understanding that we did not experience any deratings at that time. The rules were slightly different at that time, but I would have to check that.
Derating doesn't mean that the rating of ability to produce energy. Derating means a capacity accreditation derating. So the value of that capacity went down for the following 30 years because that's typically how MISO accredit this capacity and discounting the value of it.
Commissioner, I'll subject to check. I would need to check on that. I would just say that at that time, the market for capacity was, again, very limited.
Okay. So because you have enough capacity doesn't mean that there is a harm to the ratepayers. Because if your capacity is not qualified as a capacity at the MISO, and then ratepayers are paying full price for that capacity, there is a harm. So if you think that, because you are long, there is no harm, then can ratepayers keep paying for that capacity? No, that's not the agreement. Our agreement is Xcel has to bring all the capacity, be ready, and ratepayers are paying for all the capacity. That's why that 2012 rate case, there was a disallowance, right?
Yes, there was a disallowance. I think I'll go back to my original statement. Customers did not pay for any additional capacity.
I understand. I am not talking about additional payment. I am talking about foregone benefit of the ratepayers. Ratepayers already paying for fully. So that's why if we go in that route of trying to credit disallowance. Now we have to account for all this harm we didn't talk about at that time, and we have to litigate that portion. Also, if you have an insurance claim, what happened to your insurance premium from that on? If we have a roof replacement due to the hail damage, or if you have an accident with the car with a recovery of that cost, what's typically happening?
Yeah, Chair Sieben, Commissioner Hom, I absolutely track that. This isn't built out in the record. No parties asked. I mean, there was speculation on what happens with the insurance costs going forward. But what we actually see, and some of this can be seen in the rate cases that we filed, post the accident, is that there was a bump in our insurance premiums. It was about $1 million a year bump in our insurance premiums from, say, 2012 to 2016. Usually the way that the insurance premiums go is that they track the value of the property that we've invested that is covered by that insurance. And so there's a bump that occurs from 2012 to 2016, and then we see it again tracking exactly linearly with the costs of the property that we've invested. And so there is some impact, but it's not the kind of outgoing, outsized, this is going to be a huge thing that engages in perpetuity that parties have raised.
Thank you. My point is, if you want to relitigate this capacity payment disallowance, we have a lot more things to discuss, inclusive of rapier harm incurred due to this incident. So that's why I agree with the Commissioner Tuma that I think that litigation was done in the limited sense. And if you want to credit it, we have to think about other things. And I don't know whether we have a record today to discuss that issue.
Mr. Harris.
Chair Sieben, Commissioner Hom, I understand that. We understood the request to be, let's investigate whether the replacement power costs were reasonable and prudent. I think there's a clear record around that. And then what, if any, refund should there be to customers? And we built out a record on what we thought the right refund level should be, what the benefits are that we were able to provide to customers, the hits that we took as a company. Parties didn't engage in that, so that's why that record isn't particularly built out around those points. But we did try and build that out for you. I understand that you may view that as relitigating something from the past, but I think that net harm concept is something that all parties agreed with going into this proceeding. Filings from the department and from the OAG were doing that kind of netting before we came into the contested case.
Commissioner Hom, did you want to hear from the department? I think they wanted to respond.
Yes, thank you.
Mr. Mertz.
What I think that this conversation illustrates is the wisdom of the Commission's decision to focus this case in terms of its scope. And the issues you raise are potentially viable issues that no one really has looked at very hard. And if those issues need to be litigated, then they will be. But at this point, there's not a record. And I think all of these potential costs really need to go into the right bucket. That's what I take from this conversation.
Thank you. Commissioner Means, do you have questions now or? No. Okay, why don't we turn to the issue of energy replacement costs contained in decision options 5, 6, or 7. And there's a variety, as commissioners know, there's a variety of red lines from the ALJ, from the department or the OAG. If the commission goes down that route, that so commissioners, do you have questions around the decision option 5 or decision option 6? And these, just making sure I'm correct here, these numbers in 5 or 6 are not trade secret. That's correct, staff, yes. So decision option 5 would adopt the ALJ's recommendation, and Xcel agrees with that the total energy replacement costs were $71.5 million, and then 6 is using Xcel's GE litigation estimate. The department and the OAG and Xcel agree that that number is more accurately reflected as about 55 million. Do commissioners have questions in this section? And then you do, or you?
Yeah, I wanted to make sure my friends have no questions on.
I think Commissioner Tuma, one question that I have, Mr. Mertz, that I think was stated at the beginning in opening comments was, excuse me, I have a little bit of a cold. I'm trying to get over it, but what if we do some decision that includes number 7, 8, and the subparts, or 8, I think you said that you're effectively like okay with a combination of that our order writer, I think too, the other way to say it is our order writer will reflect our decision and then modify the ALJ report as appropriate. Are you kind of comfortable with that general language if that's the way we head on this?
Chair Sieben, thank you. Yes, we are. And the point that I was trying to make was just that we don't oppose necessarily the OAG's decision options.
Right, and some of the actual red lines might change a little bit too based on other decisions we'll make later, so.
That makes sense.
Mr. Murray, you're okay with that too, general direction?
Thank you, Chair Sieben. Yes, we are okay with that approach.
And Commissioner Tuma?
Yeah, now you can hand it out, Jason. I struggled with my friends from OAG and
A little louder, Commissioner
yeah,
Tuma.
I struggled with the redlining that you did. Not that it's a bad thing. I think it's going to be informative for our order writer, Mr. Davis, to be instructed. But I guess I wanted to make sure he had freedom. So read 6, 10 and 19 are kind of similar concepts, but 6 is what we're on right now.
So Commissioner Tuma, just to be clear, this is what you would propose that we do just as for red line modifications if we chose decision option 6?
So instead of doing 7 or 8, you would just do 6A. So you do 6 and 6A if you were to go down that, if you're determined that you support the department's position on 6. 6A, I hope, would do the same thing you're trying to accomplish, but we just give the freedom to the order writer to reflect the decisions we make today, as opposed to trying to get into which of the departments and which of the OAG's red lines we should select and start doing side-by-sides, and it would quickly deteriorate into the debate about where the "the" should be put. So
The tricky part, Commissioner Tuma, is we haven't heard from other commissioners, like if they support 6 or 5. And so I'm not trying to get too far ahead of.
I'm
not trying to get to deliberations yet. So just, I think it's important to say that if the commission supports going with 6, then you would support 6A as written here that modifies does it modify both it kind of modifies the DOC and the OAG's 7s and 8s instead?
It's
Is
trying
that
to
the way to think about it?
It's trying to capture their ideas, but give our order writer some leeway in how he words it is the goal. So yes.
And then it's not just your 6A is not making any assumptions about later conclusions the commission would draw, right?
That is correct.
Just trying to read this on the fly too. So who do you want to hear from first?
From the Department of OAG, because
Mr.
they're the ones
Mertz,
that
I
did all
think.
the redlining. Which redlining is good. We've been told that by the courts, so I'm trying to make sure we listen to them. But
Mr. Mertz, I don't know if you've had time to look at this or to really understand, like modifying the findings, the ALJ findings of facts 323 to 332. But if you need time to look at it just to make sure, or you're okay with it, let us know.
I thank you, Chair Sieben, and I have looked at this, and I think it's consistent with the idea that I was expressing earlier. I think it picks up the way we would kind of modify the ALJ's order kind of with respect to the idea, and then it allows your order writers the way to implement that idea, and that's fine with us.
And Mr. Murray, any reactions to 6A?
Thank you, Chair Sieben. Similar reaction to the department. We're comfortable with the approach.
Ms. Lee, anything to add on this? Or you're for decision option 5, so maybe you don't want to comment.
Well, if I could comment, that'd be great. Thank you. Chair Sieben, Commissioner Tuma. So I think Xcel, I would understand what Commissioner Tuma is trying to do with 6A. I just wanted to point out that the Commission is soon to order a contested case in the fuel clause docket for Xcel on the Prairie Island issue, which I understand the Commission wants to look very carefully at the methodology to be used to calculate the replacement costs. So I don't know if we could somehow borrow from that proceeding and issue the refunds now, but perhaps true up to using that methodology once it's determined in that contested case process.
Problem is that contested case will likely take a while, right, Ms. Lee? I mean, we just sent it. The order probably hasn't even gone out yet for it to go to contested case, but you're proposing that whatever methodology that ALJ suggests there, that if the Commission agrees with that methodology, then we should retroactively agree with the methodology here.
Yeah, I think that's pretty much what we're proposing, Chair Sieben. You know, the timing would need to be worked out, but the refunds we would like to see issued with a compliance filing, you know, that perhaps uses the methodology that will be refined in the contested case process.
Ms. Lee, isn't the struggle, but isn't the struggle here, again, that's the methodology for a future decision on rates that are done in, later years. The struggle with this whole one was, how do we recreate a fair determination of what the actual replacement costs that ratepayers did in a couple of years, which is pretty complicated, as I think Commissioner Hom has just showed us. There's a lot of complications that go into it. And so I don't know if that's going to provide us any instruction, because this was already a struggle to try to get this old case on old principles and old structures determined. So that's why I'm struggling with. That's why I kind of like where the OAG and the department have landed, is that, yeah, we thoroughly looked at this is about the best we can do. That's what for this case. I don't know what's the new case going to tell us.
Well,
Ms. Lee.
Oh, sorry, Chair Sieben, Commissioner Tuma. I think that we're curious what the new case tells us and what we might be missing. So if that's our best look in a way that we haven't yet developed the methodology, we just thought it would be nice to rely on the best evidence.
Well, and Madam Chair, and to the Department OAG, I think that's where you guys kind of landed, was not perfect, but this is the litigation look was probably the most thorough analysis given the realities of the day at that time. Is it perfect? No, but it's better than what we did with the AAA, which was built around short outages and smaller numbers. That's the way I see it. Am I wrong?
Chair Sieben,
Mr.
Commissioner
Mertz.
Tuma, no, you're not wrong. I think that there is no perfection in this kind of problem, but we did feel like the analysis and the estimate that was prepared for the litigation took into account a greater number of factors, a more granular look, and so therefore was more accurate. And even though it kind of cuts against our interest in terms of the amount of the refund, it reduces the amount of the refund, but we thought that was the approach that was most fair and most appropriately reflected the record in this case.
And it might instruct a future docket on, say, Prairie Island, but it's not necessarily the end of all. There might be more information in the Prairie Island situation that you're going to look at that makes maybe cut in our favor because we took this more thorough look.
And of course, parties will still be able to say, look, here's what you did in that Sherco case, you should do the same thing. That argument's going to be available to people, right? Yeah, that's where I would come down.
That's what I thought.
And decision option 6, it says that we would use the GE litigation estimate, and the department and the OAG and Xcel include that. It doesn't include the phrase "with interest," which the commission would pick that up later, is my understanding. But decision option 5 does say the ALJ and XLI are recommending we adopt their estimate with interest. And Mr. Mertz, do you know why there's that discrepancy? Does the G litigation estimate, did it already include interest, or would it still be, would the interest be calculated on if the, like, say, for example, the decision decides to include the prime interest rate, then that would be applied to the 55 million?
That's correct. It needs to be added on to the calculation that was done in the GE litigation. I don't know why. I don't know the reason why there's that discrepancy in these options, and from our perspective, we weren't really focusing on that difference. We do believe, obviously, that interest should be paid.
Yeah, that comes in a different decision option. Mr. Harris?
Yeah, Chair Sieben, and we agree that interest should be factored in here too. That looks like those are decisions 22 and on is kind of where interest comes in. Just one thing to clarify, though, is that the $55 million number, I believe, actually does include some portion of interest in it, and so you'd want to make sure that you're just thinking about those numbers clearly as you're ordering this. I think, frankly, 6 and 6A provide the flexibility to get there.
And then the actual calculation, depending on what decision we make about the interest rate, will be done in a compliance filing that would come in decision option 25, and then that will be an opportunity for the department and others to review that calculation, correct?
Chair Sieben, that's right.
And along that same line, there are pieces of this, and we haven't talked about it yet, that are trade secret. But when the commission makes a final determination on the amount of refund that is due to customers, that will contain, I assume, a portion of the overall refund that is trade secreted. How do you propose that we handle that issue? Because I think it's in ratepayers' best interest to know, like, what we decide today. And I don't know if, and then we don't want you to then, though, say, you know, someone could, like, reverse engineer the math and determine what the trade secret amounts were and the percentages. So I'm just curious if you've thought about that and have any idea of how to handle that trade secret component of the overall decision today.
Yeah, Chair Sieben, I'd love to tell you that we had a really good solution to this. We've reached out to GE to see if we can make the settlement number public. Obviously, it's been a number of years since that settlement occurred. They're unwilling to agree to do that. And so I think that we'll just have to be careful about how we talk about it and avoid that kind of reverse engineering in it. I don't know exactly what the best way to do that is at this point, though.
And then will the compliance filing then be trade secret, assuming that is the case?
It would have to have portions of it, I expect would be, depending on your decision is today, it would likely have portions that are trade secret.
Okay, so I think that's just helpful for everyone to understand then. There won't be like a overall talking about the number after we make up all the decisions, because a piece of it's trade secret and we can't.
I think you couldn't talk about the bottom line, because if you're going to net out some number in it that is trade secret, it's going to be easy to reverse engineer that. But other piece parts of whatever your order is can be talked about publicly, and so that's, I think, how I would propose it, which is that bottom line refund wouldn't be able to get there.
Okay, Mr. Mertz?
That strikes us as pretty problematic. I don't know how you can not tell ratepayers how much of a refund is coming. I mean, this is important information the public has an interest in. I don't have an opinion because I frankly don't really understand why, after a dozen years or so, this settlement is still so confidential. if they feel
So
it needs to be
what will-
protected, they can protect it in some other fashion. But I think customers need to know the amount, the outcome of what the commission's deciding.
Then what
here.
do you propose we do, Mr. Mertz, if we're making a decision about trade secret information, that the actual dollar amount is trade secret? How do you propose we talk about it, including your agency as making a public determination then?
One potential option, it strikes me, is to have the final number be public, but how you got there be non-public. And so the thing that they're
File
trying to
number
protect,
won't tell customers what the total refund is, though.
that's what I'm asking for, is that the bottom line number be a public number. The amount, the total amount of the refund is information we think ratepayers should be allowed to know. How you got to that, which I think is the thing that discloses what it is they claim is to be trade secret, I don't know that that's important, but the outcome, I think, is.
Yeah, but people are smart and can do the math and then determine what the trade secret amount was of the GE settlement. So I'm not trying to be argumentative. It's just like a fact of this case that we're going to maybe parties can talk about it over the recess if we get there. And, because I think there is like an obligation to tell the public, depending on what we decide, you're going to get a refund of X dollars. Maybe it could be a range, perhaps, that we're saying is customers will see a benefit of between what the GE settlement is just a small portion of the overall decision, so it could be a range. Mr. Harris, any other thoughts? Because Mr. Mertz doesn't seem to like the idea of keeping the number not public.
Chair Sieben, I struggle with it just given the other numbers that have been disclosed already in this proceeding. To your point, people can do the math on this. One option that we may have is to just order us to confer and see if there's an opportunity to address this, amongst the parties and see if we can figure out a way there.
Before
I think
tomorrow's newspaper article on this, Mr. Harris, what do you think that really the reality
I think
here
that
is
if there's
that
a newspaper article on this, it would probably have to be trade secret at that point too. But I'm thinking for down the road, let's call it before an actual refund is made, there may be opportunities. I don't know exactly what that looks like at this point.
Madam Chair has a good point.
wait, Commissioner Tuma, Commissioner Hom had his hand
sorry.
up too.
Thank you, Chair Siebert. So here is a proposal. Why don't you exclude the GE settlement impact totally out of the final number and give that number to the public and tell public either that will go up or down based on the GE settlement impact to it, which is not that huge compared to overall. So at least public will see the overall number excluding that impact from the GE settlement. But you can mention that that's a trade secret, so we cannot include in the final number, but that will increase or decrease the final refund. So directional is okay, I think, but we can see the final number excluding that GE settlement.
Mr. Harris?
Chair Stephen, Commissioner Hom, just so that I'm tracking here, it would be the full replacement power cost, whatever that amount is. And then we would just say that the commission is ordering a refund of whatever that number is, less some undisclosed amount, or plus some undisclosed amount due to settlement with GE.
So because all the other numbers are public.
Correct. Yeah,
Except for the settlement.
we would be comfortable with that.
Okay, and Commissioner Tuma?
Well, and if I'm a ratepayer, that number means nothing to me. What matters to me is what would be my anticipated refund in my bill. And I can't imagine GE is going to argue that somehow someone's going to reverse engineer an estimate of an average residential ratepayer is going to get a refund of $2, okay? And for someone to go do that math, they'd have to be Miss Campbell, okay? Okay, and she already knows the number because she's got trade secret authority. Could you do that?
Chair Sieben, Commissioner Tuma, I'm confident we can do a version of that. We'll have to think about just how easy it would be to reverse engineer from those numbers, but at that point, I think you can give an approximate range that fuzzes it up enough.
And that could probably be in the compliance filing. You'd have time to do it then and make that approximate refund in the compliance filing, which is 30 days later.
Absolutely, yes.
But for now, whatever we decide today, the remaining pieces can be publicly talked about because all of those decisions are published. Everybody agrees with that.
Chair Sieben, I agree with that.
And Mr. Mertz,
That makes
Okay.
sense for purpose of resolving this conundrum right now.
Okay, great. So where were we at, commissioners? Are there any further discussions about the calculation of what the energy replacement cost number should be? Okay, then skipping next is now we're back to the offset, this litigation settlement offset. We kind of already discussed it. We won't say the numbers, but, decision option 10 credits the entire amount against the proceed, or it's the entire amount of the GE settlement, whereas decision option 9 is just a portion of it. And, I think that my question to Xcel is, it seems to me fair that if we expect the company to go pursue a legal claim against, in this case, GE, for whatever the results of that lawsuit would be, to find, negligence on the part of GE, there is some fairness in my estimation of allowing that full credit amount to go back to Xcel, just for the very fact that then we want you to continue when there is potential negligence done on someone that's not the ratepayers, that the company would pursue that. So I'm tracking with your overall argument, and the apportionment amount here that the judge concluded is sort of similar to what happens later, where it seems like that is just it's a number that was drawn from the civil case and the settlement, and that's fine that they applied that. But it seems to me that, in my reading of it, that it is fair to credit that full amount back to, against the energy replacement cost. Mr. Harris?
Yeah, Chair Sieben, I agree. If what you're trying to do is set up a construct that looks like the cases that we were talking about earlier today, then I think that the full amount being credited back really aligns with that, where we're responsible for replacement power costs, whatever that number is, and then you've got sort of the opportunity to go and prove your case out, prove out what the responsibilities of a third party. That aligns with decision option 10. I think that the concern that we had with decision option 9, and why as an alternate we proposed decision option 11, is that 24% is based on the time that we filed the lawsuit against GE, what was sort of the sum of the claims that we had against GE at that point in time. That was before we had any insurance recovery that we've since now flown back to our customers. The amounts that we recovered in insurance, that becomes the insurer's claims. And so then when we actually settled with GE, the percentage should look something more like the 86.8% that's reflected in decision option 11 of what was remaining that we had as a damages claim related to, as sort of our damages claim relating to the repair of the unit compared to what the replacement power cost claim against GE was.
And then you just cited 11, but 12, too, would go along with decision option 10 if the commission decided that, and you agree with that because there was a little difference in the interest calculation, that would be I assume that will show up in the same compliance filing that we just talked about 30 days later.
Chair Sieben, I agree with that. I think anything that we're doing here should be reflecting the point in time that various decisions were made and various amounts of money were flowed back.
Okay, commissioners, or Commissioner Tuma?
Yeah. And I wanted to track and understand 11 and 10, and I think you've explained it. But help me if I'm incorrect. You settled a litigation. That litigation was replacement energy costs. Okay, that's what you're suing for, which I think bolsters where we're going today. But I think you also said there was some unrecovered property damage. And I think, as we've argued, property damage is another place. We've resolved that. And so, in a sense, ratepayers have paid for that. Maybe they should get that back, would be an argument, would it not be? But you're making an argument here. Things are still muddled. We would like, because of what we've done, you to make a legislative decision that you should get all of that undisclosable trade secret settlement to offset this matter today. Is that what you're saying?
Mr. Harris.
Chair Sieben, Commissioner Tuma, I think that's pretty close. I think that what you were trying to do was look just like the cases from Pennsylvania, Texas, New York, where you said, look, it's up to the utility to go and pursue for whatever cost they're gonna pursue for. Then 10 really reflects that, because that's the lawsuit that we filed. The one thing I do want to correct is that lawsuit wasn't just about replacement power costs. It was about all the damages that occurred as a result of the incident. And so it did include repair costs to begin with, but once we had insurance recovery from that, those claims were subrogated to the insurers.
That's what the insurers went in and lost on.
Exactly.
And that was the smart decision you made to settle, regardless of what it was that you settled for money, and it wisely did it, because if you went to trial, you would have likely lost that. That's the position you've taken.
Chair Sieben, Commissioner Tuma, I think you're reflecting it accurately.
And so 10 would say, whatever that settlement, undisclosable amount, all should be applied to this particular situation, which is replacement costs. And before I ask others, to dissuade me from that, I see 12 as we would add the same language within 30 days of the Commission's order in this proceeding. Require Xcel to make a compliance filing detailing the final refund. Okay, that makes good sense because things are changing. Recognizing, this is the part that I want to understand so we're on the same page and have a meeting of the minds, recognizing the timing of the GE settlement credit and other offsets, which I don't understand what that means, and to customers. So first, what do you mean by other offsets? Here I'm just talking about the credit for the GE settlement, which is a dollar amount.
Okay.
Right. And I want to give you that. At least that's my worldview. I don't know where my friends are. I want to say you get that based on the Pennsylvania principles. Okay.
So Chair Sieben, Commissioner Tuma, the other offsets here, I think the biggest example would be the prior rate case disallowance. That's where that language is coming from. Obviously, if you don't agree that there should be an offset for that prior rate case disallowance, then that language starts to mean functionally
But the
nothing.
offsets you're referring to are other sections of the decision options, and I think that's where Commissioner Tuma is reading it as the other offsets are contained in the litigation settlement.
Chair Sieben, Commissioner Tuma, I track the confusion on that, and I would say that that's not meant to reflect anything else related to the litigation.
Okay. So if we would just delete that
Strike
parentheses section, I'm still accomplishing, if this is where we go and I'm convinced of it, 10, you get all of it, okay, and just delete that, that would mean you're going to get all of that back, is just the GE settlement, nothing other games with the rate case or anything. You're going to get that dollar amount.
Chair Sieben, Commissioner Tuma, that's right.
Okay. And then help me out too, I want to make sure we're being fair here. We obviously ordered you to put that, and you agreed to do that, put it in to a prior AAA. Okay. What is your plans to then offset the fact that we held on to your money for a number of years? What is your plan when you file this? What is it going to look like?
Chair Sieben, Commissioner Tuma, there's a pretty robust record in this docket on exactly how interest can be calculated using the prime rate over time, going back to the original, incident and the replacement power costs that we incurred. I think you can look at that point in time where we made the refund to customers for the litigation, and then use that same interest rate as the calculation going forward from that point in time to figure out what the right offset amount is right now. Obviously, we would lay all of that out in a compliance filing so that parties could review and make sure they agree that it aligns with the
So I just
decision
want
we
to be
make.
clear, you're reading number 10 as with interest, like we had discussion about the prior, with interest is what you would say. I mean, we've held on to your money, the ratepayers have held on to your money, you'd be with interest, and you would say it should be treated the same as how ratepayers get their interest.
Chair Sieben, Commissioner Tuma, yes, I think that's the impact of 10 and 12 combined.
I want to look to our friends down the road here, so you've heard the discussion. Whether you agree that's where I should go or we should go or not, if we do go down that road, is that what you anticipate a compliance filing should look like, and is that fair?
Mr. Mertz.
Thank you, Chair Sieben. In terms of the mechanics that you're describing, I think that it will be worked out in a compliance filing. I do, though, want to comment on kind of the premise, and that is how do we or do we bother to allocate any part of this settlement to replacement power costs? Our position, I think, is the one that is kind of reflective of, again, this dichotomy that you established between replacement costs and restoration costs. And so the question is, how much should be attributed? And all along, Xcel took the position that no, none of it, not because it all relates to restoration costs, but because we don't think it's appropriate to look at our settlement in a piecemeal fashion. And it wasn't until the reply brief that Xcel filed with the ALJ where they finally said, well, there is some portion of this settlement that should be attributed to replacement costs, but it's not very much, or should be attributed to, replacement costs, but it's not very much because most of this settlement went to replacement costs. And so they propose a number of I think 80-some%. We think our number is better because it's the one that was kind of made when they just looking at their damages and we're trying to determine how do we characterize these damages. So I disagree with the premise. I think, Commissioner Tuma, if you're just talking about the mechanics, it sounds to me like it makes sense.
Yeah, and it's a fair legislative call. I mean, the difference between us and the ALJ is we're saying all of it, okay, and then because we want to encourage aggressive settlement, when they settle, we should give them back the fair amount of what is we're dealing with here. And in this case, all of the settlement would seem to be fair in my mind, but not being able to talk about the numbers, I think ratepayers come out ahead in that scenario than under some of the other scenarios we've talked about. And that's again a legislative decision we have to make. You would agree with that, right?
I do.
Mr. Murray, did you want to comment?
Chair Sieben, yes, thank you. We would support the position that Mr. Mertz expressed. We also kind of disagree with the idea. I don't disagree that it's a legislative decision you can make, but we disagree with the idea that the utility would need that kind of motivation to go after a company like GE. When a company like GE does what it did and what the district court litigation was about, that fact alone should motivate Xcel or whatever utility in question to go after them as aggressively as possible. So taking that money that Xcel didn't really clarify the portioning of until this late stage, we don't think it's appropriate. Again, it is your decision to make, but we also think that since ratepayers are paying the cost of the insurance, they should get those benefits by default. There's just too much here that works in ratepayers' favor that should prevent Xcel from getting that whole refund.
Ms. Lee, nothing. And then Commissioner Tuma, you wanted to talk about your 10A
exactly.
too.
I just wanted to make sure you're okay with 10A, the parties. I'm just trying to, this would require us to do some redlining, and I try to capture the same flavor here. We don't have the red lines here, but we would be empowering our order writer to redline the order to reflect our decision. Any concerns?
Chair Sieben, Commissioner Tuma, no concerns.
The ratepayer advocates?
Well, if you set aside that we don't agree with
Right,
the starting point, it continues to be our position that you shouldn't give them back anything more than 24%. But I think this is consistent with what you described for 6A, and it gives the order writers flexibility to reflect what the commission's deciding here today.
Mr. Murray?
Chair Sieben, Commissioner Tuma, agree again with Mr. Mertz. We disagree with the 100% allocation, but the flexibility is tracks.
And Commissioner Tuma, this would be, again, not modifying the ALJ report necessarily, but just language in the, well, no, it is.
It is.
It is modifying the ALJ.
Yeah.
Okay.
It's meant to, because if we do either 10 or 11, we would have to modify the ALJ. So we could, if the commission chooses to do 11, we could change 10A to reflect and work with 11 too if we had to. We wouldn't need it for 9, obviously, because that would be adopting the ALJ's position.
Okay, thank you for that clarification. Any other questions from commissioners in this section? No? Then the rate case disallowance is 13 or 14. Questions from parties in this section? It was sort of already talked about. Any further questions? No. Then the restoration work, avoided costs, and customer benefit. That's 15, 16, 15 or 16. And again, this is either, is it right? Am I remembering right? This is either the 16.2 million, which would be used to offset the replacement power refund Xcel is proposing, or no credit that all the other parties and the judge are recommending. Questions, commissioners? Okay, then we sort of already talked about, well, not sort of, we did talk about the next section.
Last really.
Then the next is really, the next really is the interest calculation, and the department is proposing the prime rate, to put it simply, right, Mr. Mertz, in 24.
That's correct.
And Xcel, what's your position in this section? Are we supposed to use the prime rate you suggest, or something else?
Chair
Mr. Harris?
Sieben, we have not suggested an alternate interest rate.
So you support the prime rate for 24?
Yeah, we don't oppose that.
My understanding, Madam Chair, is 25
We would do.
captures 23, 22, 23, and 24. Is that everybody's understanding? I don't know.
I think, well, I
requirement,
didn't have
yeah.
that, but
That's what my notes say, so they seem to be nodding, so.
25 does incorporate the prime rate. That's actually the option that I think when I opened up, I think that's what I said is 25. So
we have a long way of saying everybody agrees we should use the prime rate for this section, right?
And
Okay.
25 is a decision option.
Okay, then any questions on the commission investigation ideas proposed?
They didn't really propose it, so I think it's, I don't want to say withdrawn, but at least that's the way I read it, so.
Ms. Lee?
Yeah, Chair Sieben, Commissioner Tuma, I think we have hopefully what we need with the commission investigation and the methodology in the Prairie Island docket.
Okay, commissioners, Commissioner Tuma, did you ever talk about 19A, or did you want to?
I think it's pretty self-explanatory. It just, if we do 19A,
It's self-explanatory if you read it, which I have not, so.
if we do 19A, it would require some changes to the ALJ's order, and we authorize the order writer to make those changes.
And
If
does
we-
I know that not it, well, Xcel won't agree with that then with 19. But do you disagree with any of the suggested changes in 19A? Mr. Harris, the findings of fact references, for example, or any other concerns?
Chair Stephen, we're comfortable with 19 and 19A.
Okay. Anybody else have any comments on 19A they wanted to make? Then, commissioners, are there any other overall questions? I think we need to take a recess to allow time for commissioners to gather their thoughts, and we still have a number of decision options to consider. And I don't know, Commissioner Tuma, if you're working towards putting together a motion.
I would have a motion, Madam Chair. I could tell you what I'm thinking if you want me to right now, but.
Oh, commissioners, do you want to hear that, or do you want to break and then hear about it? Because you want to hear it? Okay. Commissioner Tuma, we want to hear from you more.
Apparently not. I don't
We're
know.
not making a motion, but you're telling us your thoughts.
This is my thoughts. I would do 2, in addition to 4 that's already done. I would do 6 and add at the end of that with interest, as you suggested, Madam Chair.
Or that will be picked up later, but either way.
Either way, yep. Just it's belts and suspenders.
Clear.
Then 6A, then I would do 10, and I would put in at the end of that sentence also with interest, again, belts and suspenders. I would do 10A. I would do 12, adding the language within 30 days of the commission order in this proceeding require, and then the rest of it, and then delete the words in parentheses and other offsets. I would do 14, I would do 16.
Wait, slow down.
Oh, sorry.
Okay. Right?
And then I would do 19 and 19A. And then I would do 25, and I would just change the word compliance requirement to compliance filing. I guess that's the way we just referred to it in other areas, but I think it says the same thing. So that's what where I was falling and thinking in my.
And on 25, when you do, didn't you say you were also doing 22, 23, 24?
My understanding is 25 encompasses all of
Okay,
those.
got it. I'm a little slow.
So that's the way my notes are telling me.
Okay. And then does 25 and your modification take into account enough about the trade secret stuff?
I
Or-
think that kind of handles itself, Madam Chair, is the way I would see it, unless we want to take on GE and say it's not trade secret
No, we
and
just-
go through a process, but I think that's not worth it at this stage.
And Mr. Harris?
Chair Stephen, I think consistent with the conversation we had earlier, we'll be able to handle the trade secret information.
Okay, so the commission will be allowed to say, and the parties will be able to inform the public about all the decisions made and the calculation of that number, more or less. I mean, with interest will kind of have to be calculated later, and then the litigation number will just be kept out of it.
I'd be open to some language, Madam Chair, if you want to be a little bit more thorough in what we ask them to do, because I agree with you.
But that's your general understanding, Mr. Harris?
Chair Stephen, that's correct.
And I see Mr. Mertz nodding.
Yeah, that's correct, Chair Stephen.
I don't know if we need other language.
Tracking, that's what matters.
Commissioners Hom and Means, do you still want to take a break and like think about other ideas, or I don't know.
I don't need a break. Commissioner Tuma's proposed motion is pretty well tracks where I was.
Commissioner Hom? Staff, do you think we need a break to go over anything, including the compliance filing, or you're good? Okay, Commissioner Tuma, why don't you, with the help of Mr. Davis, or put your motion out there one more time, and we'll, before we go into deliberations, parties, is there anything you want to, I don't want you to try to re-argue your whole case, but if you see any problems with Commissioner Tuma's motion that you really want to object to or state your case for, you're welcome to now. Mr. Mertz?
I don't have anything further. I mean, we've made our position clear, and there's nothing more for me to say about it, so.
Okay, thank you. Good? Great. Commissioner Tuma, from the top again, please.
The top again, I would move decision option 2, decision option 6, 4 has already been adopted. I would change 6 to add at the end with interest. Got it? And then I would move my 6A as handed out. And then I would move number 10 again at the end with interest. And then my 10A. And then I would move 12 with the following modifications. At the beginning of the sentence, within 30 days of the Commission's order in this proceeding. I don't know if there should be a comma there or not, JD, but you're. And then delete the and other offsets language that is in parens. Then I would move 14. 16. 19. And my 19A. And then 25, I'm just changing the word requirement to be filing. That's my motion, Madam Chair.
And that included number 2, right?
That is correct, Madam Chair.
Okay. Any other discussion of Commissioner Tuma's motion? Commissioner Hom.
Thank you, Chair Steven. For the G litigation portion, I was thinking supporting it 9 or 11 in the beginning of this proceeding, but I heard your argument about we need to isolate this issue with replacement energy only. So that's why, in that reason, I can support your motion. But company still has an incentive to do it outside this 100% assigned to it, because under the regulatory compact, that's their duty. It's their fiduciary duty to protect the ratepayers, so they have to do it. So I don't want the company to have an idea that unless we give them 100%, they shouldn't pursue it. But with a different reason, I can support that one.
Understood.
Commissioner Means? Okay, thank you, Commissioner Tuma, for your leadership and your legal analysis in there. I enjoyed it and appreciated it, and I support your motion and look forward to this ongoing issue being resolved now. So all in favor of Commissioner Tuma's motion, please say aye.
Aye.
Aye. Opposed? The motion prevails 4-0. Thank you very much, everyone, for your work on this. There's no other business before the commission, so we are adjourned for the day.
All before noon, like I promised.